The other thing with location drawings is if in the event at some future date, your client now wants to get a boundary survey because they want to do a fence or something, usually that surveyor they use, they're able to knock out the price that they paid for the location drawing from the total of the survey, the boundary survey. Okay? All right. So while everything else is going on with the lender's portion, the file is still processing, right? So at this point, we've gotten the HOAs, we've gotten the payoffs, we've cleared any judgments, and we're now reviewing the file. We're checking to see if there are any errors with the names. Names are very important. That's a very common issue. So we check for that. If we haven't ordered the payoffs, we're ordering that and waiting for that to come in. We're at this point also waiting on the lender's instructions, trying to get their information, their figures, and working with the lender to just make sure that the lender has all they need to move forward to the closing date. We start working towards preparing the documents, and then we start to contact you guys or contact the buyers and the sellers directly to schedule the closing. So at the point where we are getting closer to the closing date, we always have to do a title rundown. Now, what is a title rundown? So remember, at the beginning of this class, I talked about the title commitment. When an abstract is done, a title commitment is then issued. So the title commitment has a good through date. And what that means is, hey, the property has been checked in the land records, in the public records, through a certain date. So anything after that date, so if a mortgage was recorded after that date, it will not show up on the title commitment. So that's why between when the title commitment is issued and the date of closing, another rundown has to be done. So it's basically checking the public records for any new thing that could have been recorded in the county after that commitment was issued. Basically, after the abstractor did their search. And trust me, it does happen. So again, that's why we say, if there are any changes to your contract, you need to notify us immediately. So we have a contract, a file has been sitting, it's been pushed, and the closing date has changed several times, and we haven't heard anything about this file for 3 weeks. And then one day, a day before, a nice Thursday like this, we get a call from the agent saying, hey, or the lender, hey, we're ready to close tomorrow. Yeah, you may be ready to close tomorrow, but we have to update our file. And that includes reordering payoffs that may have expired, HOAs, front foot if it's in the state of Maryland, water. And again, we have to go back to, bless you, we have to go back to the public records and check to see if there's been anything new that's happened after the last time it was checked. So when it sounds like when the title company is like, oh my goodness, you really want to close this tomorrow, or oh my goodness, I'm not sure that we can close this tomorrow because we have to update the file, it's because we technically have to go through the process again that I just went through with you. Okay, and there might not be enough time. So again, that's why we say, as soon as you know, if it's a file that has been pushed several times, or if it's a file that is closing earlier than the contract date, you need to let us know ASAP. This is what you're thinking, because then we can begin to prepare ourselves and prepare that file for the eventual whatever comes next. But if you just come to us the day before closing and say, hey, well, this file that has been sitting down for 3 weeks or a month or 2 months, well, we want to close it tomorrow, we're likely going to say we need more time. Okay? Any questions? All right. So we've done the rundown. We have all the payoffs. We have the HOAs. Everything on the commitment in Schedule B1 has either been satisfied or cleared, or maybe they don't apply. Here comes closing dates. You come to closing. Now we have sellers signing at a different time. We have buyers signing at a different time. Or we may have buyer and seller signing at the table. This is the job of the escrow officer or attorney is to conduct that closing. So in some states, that job has to be done by an attorney, while in other states, it has to be a licensed person. So the escrow officer or attorney sits at the table, explains the documents to the buyer and the seller, completes the signing, makes sure all the documents are notarized, and in situations where a lender is involved, the documents may need to be sent to the lender for the lender to review the documents and give the okay. Now, this is a state-specific thing. So in states like Virginia, you have to record before you disburse. In states like Maryland and DC, it's a wet settlement. So that means as soon as you're done signing, it's done. The file can disburse. However, there are some lenders that will have funding requirements. Their funding requirements are, this doesn't mean that they're not providing us with the funds. The title company already has all the funds in, but the lender is saying, well, before you disburse those funds, you need to scan us the documents that the buyer signed. We want to make sure there isn't any mistake on it. This process usually is very quick. Once the escrow officer / attorney is done with closing, the post-closer scans the documents to the lender. Lender reviews all the documents to make sure that there are no mistakes. There are no mistakes, they say you're authorized to disburse. And at that point, if it's a state like Maryland, that file disperses. You have to be aware that when they say Maryland, for instance, is a wet state, this only refers to consumer transactions. So if you have a private lender, it's an investment deal or commercial deal, that lender is not under any obligation to fund the loan and for you to disburse right after signing. In fact, we do have situations where the lender will withhold funding till the buyer signs, then they review the documents and they've made sure there are no corrections or there are no issues with the documents that the buyer has signed. And once they've confirmed that everything looks fine, then they will initiate their wire. So remember, when it comes to wet settlements, it's only in respect to consumer loans. And consumer loans are loans that are given to people for homes, for instance, they're going to live in, or a member of their family will live in. Okay, so your principal residence or like a second home. All right, so at this point, we've had the closing. Everything is fine. Everybody's happy at the table. If there is a lender involved, the lender has funding requirements. The documents have been sent to the lender, scanned over to the lender for the lender to review the documents. If it's a file that there's no lender or the lender doesn't have funding requirements, everyone has signed, the loan the proceeds of that sale can disperse. So the file can completely disperse and everybody can get their money. So once we do that, it's not over. It is not over. it moves to the post-closing department. Now, this is the last-ditch effort. So the post-closers are the ones that will review all the documents, whatever has been signed, to make sure that there are no errors. This is our last attempt to catch any issues or any mistakes. So I would not be surprised if one or many of you have gotten a call after settlement from any title company you've dealt with and said, hey, X and Y and Z happened, and we have to do X, Y, and Z because a mistake was caught at post-closing and it needs to be taken care of. So anyway, once the post-closer has the file, they go through the documents, make sure the signatures are correct. They disperse the file they pretty much just send all the monies out to whoever it needs to go to. And then they send the documents, if there is a lender, send the documents to the lender. And at that point, they send the documents to the county to get recorded. When the county records the documents, it comes back to the title company. And when we receive the recorded documents back, we send it to our title insurer or title issuer to issue the title policies. Title policies are issued to the owner and the lender, and they're mailed out. Okay? There are two types of title policies. We have the owner's title policy and the lender's title policy. The owner's title policy is totally, so if you don't get your owner's title policy, you cannot rely on the lender's policy. I get asked that question a lot. Well, you know, I've heard buyers who say, well, my lender got a policy, so I don't need one. Well, the insured party for your lender's policy is your lender, not you. So whatever happens, you cannot rely on your lender's policy if you have an issue with the title to your property. Owner's title policy is usually optional, but again, it's the best investment when you're buying a property because it's a one-time premium, you pay it at closing, and it covers you throughout the ownership of your property. If you do get the enhanced policy, it does not expire. So that's something that I will always recommend, not because I'm a title agent, but I mean, you're literally just buying peace of mind. And it's the cheapest type of policy that you can get.